Welcome back to Uncivil Law. Today, we're peeling back the latest curtain on the legal case that is the state of Florida versus Sarah Boone, a case that's packed with more emotions than a yoga class on steroids. So buckle up as we navigate through judicial acrobatics that would make even Cirque du Soleil envious. All right, let's jump on to the meat and potatoes of today's legal feast. Motions, and more motions. You'd think we're at the middle of a school dance with a number of moves being thrown around here. Sarah Boone, representing herself, has been filing motions like they're going out of style, hoping one of them will stick, but alas, this court is a particularly tough crowd. First up, we have Boone's motion for reservation of proposed costs to acquire an investigator and witnesses for her defense. Now, I do admire the ambition, but here's the kicker. Boone's request for all costs was so vague that even a psychic couldn't tell what she was talking about. So essentially, she walked into court saying, I need money for, things. And the judge, not being known for being Santa Claus, wasn't about to just hand over a blank check. Boone was told that specificity matters. If you want the court to approve costs, you need details relating to who the witnesses are and why they're necessary. It's a little bit like asking for dessert without telling the waiter that you're lactose intolerant. You may enjoy it in the moment, but you're going to pay for it later that evening. On the plus side, Sarah Boone does have a court investigator that has been appointed for her, but mostly in spite of herself. Her prior lawyers were able to get an investigator appointed for the defense at state's expense, and so her attorney's prior investigators remain available to her, albeit perhaps not quite to the extent that Sarah Boone might prefer. Here's a pro tip for those taking notes. When filing a motion for investigative or witness costs, specificity would really help. The court needs to see a particular showing of needs, which would mean names and showing receipts. Moving on, Boone has also requested funds for her expert witnesses. And once again, her motion was riddled with literally more to be determined than a procrastinator's calendar. The court isn't in the business of funding mystery projects, so of course, they gave all these requests a hard pass. For those of you playing along at home, here's a checklist for securing those expert witnesses. Provide the type of expertise needed, the expected cost, and a justification for why this particular expert will help the defense develop its theory of the case. In legal terms, it's making your case, not just merely throwing spaghetti at the wall. Next on our docket is Boone's colorful motion for standby counsel. She'd really liked that attorney after all, perhaps not to take her case on directly, but merely as an advisor, which sounds pretty reasonable until you remember that representing yourself means exactly that. Standby counsel's like having training wheels on a unicycle. Either you're riding solo or you're not. The judge has made this crystal clear. There is no constitutional right to standby counsel when you represent yourself. Some states may allow it, but Florida isn't one of them. Boone's hope for legal guardianship was dashed by the judge citing the particular Florida cases of Paul versus State and Jones versus State. The court reiterates that once you play lawyer, you play all the roles, not just the ones you would like. It's a sink or swim scenario, and Boone's plea for legal assistance mid-river was met merely with the resounding, "You got this, champ." Boone also filed off a motion seeking immediate relief and due process costs. This here was a Hail Mary for securing more resources for the defense. But again, she didn't provide any details, just a lot of to be determined. Without the necessary details, the court wasn't buying the motion. They denied the motion, reminding Boone that due process isn't a buffet where you simply grab whatever you want without having to show a particular ticket. The judge's decision was a reality check, emphasizing the need for proper justification for any motion. You can't just ask for an ambiguous, unlimited, undefined set of resources and then expect the court to fork them over without any clear rationale. It'd be a little bit like asking for a loan without specifying what you're going to use the money for. It's pretty much a no-go. Then we have the saga of evidence access. Boone wanted to be able to view physical and digital evidence, which sounds fair enough as far as it goes, considering she's tried to build a defense. But the court here has logistic concerns because Sarah Boone is being held in jail, awaiting her trial. Boone asked for access to 2 banker's box worth of documents, and the court said, hold your horses. Where exactly are we going to put this stuff? The jail isn't exactly a Marriott with plenty of space to spare. But the judge and the jail came up with a digital solution. Boone would receive the evidence she wanted on a USB drive. But Boone, perhaps channeling her inner technophobe, wasn't thrilled. She wanted hard copies, which led to a legal back and forth that felt like a game of ping pong. So here's the scoop. Once you're in jail, that comes with all kinds of restrictions. Handling evidence in a jail setting requires more than just a handoff because of the nature of the custody, plus the nature of the state's access to the evidence. Chain of custody, storage space, and security protocols come into play. It's not as simple as giving a prisoner a stack of papers and saying, good luck with that. The court, as well as the jail, has to ensure everything is across board, both for the sake of due process and security of the facility itself. In the end, Boone's motions were mostly denied, leaving her to navigate the legal waters with a DIY paddle. The court tried to give her a roadmap, but it's up to her to try to follow it, and I don't have high hopes. Boone still has to file her objections and witness lists by the court deadline, which is now looming larger than a lawyer's bar exam. Let's dive deeper into this mess. Boone's strategy, or lack thereof, is akin to a magician pulling rabbits out of a hat, but forgetting to check whether or not they're real. Her motions read like a wish list to Santa Claus, with requests for everything under the sun without any particular specifics. As the judge pointed out, these requests were to be determined. Spoiler, the determination is wanting. In conclusion, Sarah Boone's courtroom antics are a masterclass in what happens when an intolerable, insufferable, ambitious person meets bureaucracy. Her motions, while abundant, lack the precision needed to sway the court. It's a stark reminder that in the world of law, details matter, and assumptions are the enemy of progress. Here's a quick rundown for our non-lawyers. When you request something in court, specificity matters. You need to think of it as ordering a burger. You don't just ask for food, you specify you want the double cheeseburger with extra bacon and no pickles. Boone's motion, on the other hand, were the equivalent of saying, I'll take something edible, please. And the court, understandably, isn't running an all-purpose cafeteria. And if you think that's where the drama ends, oh sweet summer child, think again. We got trial dates set up for October 7th, running through October 21st, with Sarah Boone at the helm. The court graciously extended the trial period to 3 weeks, probably to account for the amount of eye-rolling this case will require. The pre-trial is scheduled for September 26th, giving Boone some more time to figure out how many motions she can file before finally running out of paper. Now, Sarah Boone might be understandably frustrated, perhaps as frustrated as a person left in a suitcase, unable to escape. I mean, who wouldn't feel frustrated after 4 years of legal tango? But here's the real deal. Trying to prepare your case in 62 days when you have yet to have a full grasp on discovery is like running a marathon with one shoe. And speaking of shoes, Boone's next steps seem shakier than Cthulhu on a caffeine rush. She's got deadlines looming like student loans, and she's looking for legal loopholes like they're Pokemon. But hey, at least she's tenacious, and you got to admire that. Kind of. That's what happens when you manage to scare away 8 prior lawyers the court tried to appoint for you. The court's decision is simply ruling that the show must go on, and if no one will have you because you're just that insufferable, you'll be required to go it alone. Good luck with that, I guess. So, what have we learned today? If you're going to represent yourself, come prepared. The legal system doesn't give out participation trophies, and Sarah Boone's motions are proof of that. Of course, as this case develops the actual trial, we will see what I'm sure will be a legal soap opera, where every motion is a plot twist and every ruling a cliffhanger. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.